November 8th meeting of the Board of Podiatric Medicine. I'd like to call the meeting to order and like to do a roll call. Kathy? Time for roll call.
Dr. Michael Zapp,
Present?
Dr. Judith Manzi, present. Darlene Elliott,
Present.
Christina Dixon,
Present.
Neil Mansdorf, absent.
Do we have a quorum?
Yes, we do.
Thank you. I'd like to welcome everybody, including all of our guests. If anybody would like to introduce themselves, they're welcome to. I'd like to make an announcement that the board may not discuss or take any action on any material raised during the public comment section of this meeting, except to decide whether to place that matter on the agenda for a future meeting. Thank you. The next item on the agenda is review of the minutes, which you'll find on tab 4. Are there any comments about the minutes?
I have a quick comment. Just a quick correction. My last name has one T. On the bottom, it still has the 2 T's. So just for consistency. Thank you.
Thank you. Make that change.
Any other corrections, comments? Do I hear a motion to approve the minutes?
So moved.
A second?
Second.
All in, let's start from Dr. Manzi. State your name and whether you approve or not.
Judith Manzi, I approve.
Christina Dixon, aye.
Michael Zaff, aye.
Darlene Elliott, aye.
That motion carries. Thank you. Next, we're going to receive an update from the Senate Business, Professions, and Economic Development Committee. Ms. Sarah Huckle, the committee consultant, will make that report.
Hello, everyone, and thank you for having me today. As you know, I generally handle Board of Podiatry issues, but Sarah Mason, my fellow committee consultant, was handling your bill because of where it is in the code sections. And unfortunately, because today is the last day to amend bills on the floor, we're very busy and she was not able to make it today. But she did send me remarks that she was planning to give. So apologize for reading straight from this, but here we go. Thank you, Mr. President and members, for the opportunity to provide a brief update on Senate Bill 798, the Sunset Bill for the Medical and Osteopathic Medical Boards of California, which is authored by our committee chair, State Senator Jerry Hill. The bill continues the operation of the Medical Board for 4 years and subjects the Osteopathic Medical Board to legislative review in 4 years. It has been substantially amended throughout the process, and I believe will also be amended today. It does still contain a number of important cleanup provisions to better reflect the key role of this board in licensing and overseeing doctors of podiatric medicine. Article 22 of the Business and Professions Code was never properly restructured to reflect the change from the former Podiatric Medicine Committee to the current board. When that change took place, the word committee was simply replaced with board. What has remained is a confusing and messy statute. The fact that this section is in the Medical Practice Act at all dates back to the committee, which was previously under the Medical Board. I know there's been discussion recently about changing the name of this board and making other substantive changes. Our committee is always happy to engage in any discussions with this board staff, and of course members of the profession. Since SB 798 did not propose any changes other than code cleanup for this board, a Board of Podiatric Medicine name change will require discussions down the road outside of this bill, which we are always available to be a part of. That concludes Sarah Mason's remarks. If you guys have any questions for me, I'm more than happy to field them.
So Sarah, the name change, we haven't put that on an agenda yet, probably upcoming. And so when we do that, we'll have some discussion with you and maybe next legislative cycle, have the board weigh in on different languages that the board could be termed as. But I'm looking to put that on the agenda.
And Brian's been fantastic in reaching out to us, and we appreciate the check-ins because we've got so many things going on that every outreach is important.
Could you do, or does anybody have any questions about that? Could you do a little snapshot of the fee increase? What is that, 547?
That language was the identical language that you provided to us last year, and that remains in the bill. We're hoping to take that bill up on the floor on Monday. Assemblymember Lowe will be handling that bill for us. And then the processes, any amendments that happened in the assembly on that bill, there were a number of them, including some for the Board of Registered Nursing, will have to be sent back to the Senate for a concurrence vote, and then it goes to the governor's office. We have been in communication with the governor's office, and we don't believe there are any problems with 547. And there are no issues with the podiatric portions of 798, but 798, the medical board issues are still somewhat in flux. We're hoping to resolve all of that before. Don't worry.
Like a bad math problem, right? I think that's all I have.
Okay,
Thank you very much.
thank you. And I apologize, but I have to run back to the Capitol. But as always, you know how to reach me, and look forward to working with you again in the next legislative session.
Thanks, sir.
Mr. Chi here?
I can pretend to be Vince for a second. to my knowledge, all of Assemblymember Lowe's sunset bills are moving along as well. We haven't had any hitches with those, so at least as far as the Senate and Assembly. Do you have any questions that I might be able to answer about those?
I think we wanted Vince to talk about 1153, the progress of that, and it looks like everything's going through, so. Unless the board has any questions. AB 1153.
We do encourage the board to submit signing letters to the governor when it does reach his office. That's always appreciated.
Okay.
For all the affected bills.
All right, well, thank you again.
You're welcome.
Thanks, sir.
So, okay, David, Chris here. All right, next item will be receiving an update from the Division of Investigations. There is Mr. David Chris.
Good morning. My name is David Chris, and I'm the Chief of the Department of Consumer Affairs Division of Investigation. And this morning I'll be providing an update on the Division's Health Quality Investigations Unit. That's the unit that provides investigative services for this group. HQIU, their current investigator vacancy rate is 28 vacancies, which is 36%. Several things have been done to mitigate this investigator vacancy rate. We're in the middle of conducting a massive hiring movement as we speak. All new cases that were normally worked by HQIU for the Board of Psychology and the Board of Osteopathic Medicine were transferred to the IEU side, that's the Investigation and Enforcement Unit, to alleviate some of that workload. We also started a pilot program and hired 15 non-sworn limited term special investigators to assist with the lower priority cases during this time. We're actively recruiting and hiring for investigator vacancies, and there are 20 candidates in background. The peace officer background section can slow things down considerably, but we have 20 candidates in background currently as we speak. One area that was affecting retention and recruitment of investigators was pay. And I am very pleased to report that a 7.44% recruitment and retention pay differential for DCA investigators was ratified by the legislature and took effect July 1st, 2017. We've been working on this pay proposal for 2 years, so we were very, very, very happy. And we've also noticed a significant improvement improvement in the amount of applications and the quality of applications that have been received. Investigators have an opportunity to receive this pay differential once they receive the top pay step of their salary range. We're also in the process of making a recruitment video for D of I and plan to have that video accessible through our website to attract interested parties for the investigator positions. Our training unit has planned a 3-week mini academy classroom instruction for newly hired investigators, and that'll take place in October of 2017. And then effective July 1st of 2017, HQIU started a new case disposition procedure with the medical board to streamline the procedures for processing completed cases. This will include cases from the podiatry board. These new procedures will make a huge impact in the field offices, and staffs are very excited about the changes. It'll actually streamline things and make it go faster. Even with the investigator vacancies, HQIU is dedicated to completing thorough and timely investigations. The average days to complete investigations for the podiatry board was less than a year, and we have completed 27 cases in fiscal year 16 and 17. Currently, there are 41 active podiatry cases at HQIU for investigation. And that concludes my update. I'd be happy to answer any questions.
Comments or questions?
Sure.
Where do these applicants come from to be investigators?
You know, it's from a variety. A lot of times it's people who are involved in mainline law enforcement, and they're looking for a change, maybe to get away from the shift work and work, solely more investigative function. We also have an interest of people who are retired law enforcement people who are looking to either supplement their income or continue to work. And then there's also people who are fresh out of college who maybe their interest was in criminal justice and they'd like a law enforcement job, but they don't want to work that shift work that the police officers do. And so the medical type cases are interesting to a lot of those young people, but they don't have that experience. And so for those individuals, we need to send them to a law enforcement academy. But we do have that. And also one thing that we've added recently that's been a huge success for us is these non-sworn investigative positions that you don't need an academy for. So those are the people who recently graduate from college. They're very interested in that because it's a way to look at our profession and look at the type of investigative work that we do and see if it's a good fit for them. It's also a chance for us to see if they're a good fit for our organization. And so if they get hired on a limited term basis and work those positions, then if they work out and if they're interested and we're interested in them, we can send them to an academy. And so it's kind of like a minor league baseball team. So we continue to cycle those people through who are successful and feed them into the sworn positions.
So all the investigators are actually sworn.
That's correct.
Okay.
Yeah, the permanent investigators are sworn. We have a pilot program just to kind of fill the gaps in those vacancies for now, but those are limited term positions.
I have a question. What does the pool of applicants look like? Is it a diverse pool? And what are
Yes.
you doing to ensure that it is diverse?
It is very diverse. It comes from, as I mentioned before, that full spectrum of age groups. We like to have a very diverse group of individuals who can be successful in all types of undercover applications as well. And so it helps us. Some areas that we have investigative work are different culturally, as far as ethnic backgrounds. And so to be successful as an organization, we need to be diverse as possible. And so we reach out to everyone. A lot of our recruitment is done at colleges, at local law enforcement academies, and then whoever else applies. Any further questions?
I'd just like to echo, I know being retired in a position you were in, The backgrounds, those are always the sticky part. You can have a pool of candidates, great candidates, but it's getting them through the background. There's a huge failure rate there.
That is true.
Yeah, so it's good to hear that you have 20 in background. That's a good
It's a good
grab.
number, yeah.
It's a good grab. So
Yeah, and we've had some real things that we can get our hands around, like, you know, pay raises and
Yeah,
process changes and
that's
things.
huge. That's huge because in law enforcement, it's all about the dollar, and people want to work for the highest dollar possible. So that little stipend that you got for the upper step, the 7% is a way to go.
And we've already noticed a difference in the applications.
And I know the battles. It took
Yeah.
you 2 years. I know.
Yeah.
I know the long battles.
Hard
so that-
fought,
Yeah.
but we were successful. So we are absolutely committed to doing the very best work, you know, for your board. And I am available at any time to respond to questions or to give specific help regarding cases, and do anything we can do to, you know, provide safety to California consumers.
All right, Chief.
Thank you.
Thank you.
Thank you very much.
Thank you.
We ready for number 8?
We have Gloria. Let's
Okay.
see.
Next, we're going,
Gloria's not here yet.
okay, so hold that one for now.
Hold.
So now we move on to our in-office reports. We're going to go through the executive director's report. Do you have any comments before the program reports?
I do not.
All right, we'll start with the licensing program update. Ms. Damian.
Good morning. Happy Friday.
Happy Friday.
So we'll start off with the new licenses issued and renewals during the fourth quarter of fiscal year 16-17 between April and June 30th. In April, there were 8 permanent licenses issued. In May, there were 9, and in June, 15, for a total of 32 newly licensed DPMs in Q4. Moving on to renewal information, in the month of April, there were 81 renewals mailed with 90 renewed by the end of month. May had 78 renewals mailed with 76 renewed, and June had 80 with 88 renewed by end of month. Moving on to the resident information, the resident academic year started on July 1st and will end on June 30th, 2018. BPM currently has 39 first-year residents, 41 second year, and 41 third year, bringing the resident license total count to 121. Moving on to the American Podiatric Medical Licensing Examination, Part 3 update. The last Part 3 exam was administered on June 7th, and there were a total of 32 candidates that requested their scores be sent to California, and of those candidates, 30 passed for a 94% pass rate. The next exam will be held on December 6th with a registration deadline of November 28th. And finally, we have a Breeze system update. Effective June 13th, the BPM went live with online renewal transactions. Licensees now have the option to either renew online via the Breeze VO system or download the renewal form from the website to mail in for manual processing. Renewing online is the fastest and most efficient way for renewal, as the system will update as soon as payment is received. In order to renew online, you just need to register your Breeze account at breeze.ca.gov. What I got.
I have a couple questions.
Okay.
So on attachment A, I'm noticing for the month of May, it looks like the new licenses are down from prior year. Do we have a target of how many new licenses we're looking to have for the year?
For the whole fiscal year, there was 75 for 16-17.
Right, so we're down by 4. So for like, have we thought about the target for this year and what the strategy will be to make sure we're getting new licenses? Because that's important for sustainability of the board, right?
So it's basically I'm in contact with all the applicants. I contact them on multiple occasions to let them know what's missing, whether it's transcripts. Lately, background clearances have been taking longer than usual. And we also have the expiration, birth month expiration. So some of them request to have their license issued next year. I have 2 for March and for June. So that could hold up the new licenses being issued, but I do everything I can to let them know what's missing to try and get it issued as soon as possible.
So for the incomplete licenses, is that what you're talking about where because there's 27 incomplete? So what happens with those 27 and how do we work to get them completed?
So they are either missing their background clearance or their residency certification from the director. Sometimes they'll send it directly to us, the applicant, and then we have to ask them to have their director send it to us, which could take a little bit longer because they're busy. But I do just make sure that I go through my list and send them an email or give them a call and say, hey, as of today's date, I'm still waiting for these documents. And then they follow up with either their licensing board that still needs to send us their verification that they've been practicing. But I don't really know what else I could do to speed up those processes because I can't issue the license until I get all those documentation from the source.
Okay, so then what is our, like the time frame? So does it rotate every 30 days? Like what happens internally to ensure that it's moving along is my question.
The application is open for 1 year. It's open for 365 days. If the license doesn't get issued between that time frame, the app will cancel, but all I'd have to do is open up a new application. So every week I have a sheet with a checkoff list of what's missing for each applicant. And then I have emails that I send out with bullet points saying, hey, I still need this information.
Residency programs are 3 years long, and we require 2 years of residency for licensure. Do they have to complete their residency before they can get licensed in California?
No.
Or can they get licensed during the 3rd year?
They can apply for a permanent license during their 3rd year.
So we don't know how many of these new licensees are really going to be people who are practicing in California. A lot of these could be residents that are here transiently.
Correct.
So even though it says 75, that's not really 75 doctors. That could be 20 or 30 residents that are going back to Cleveland.
And I have a quick question. So the applicants that put their application in, do we have any way to track if they're men, women? I mean, if they can voluntarily tell us their background, if they're veterans, military, their
Location
ethnic?
is-
Is there any way that we could see some of those demographics? Because I really would like to, going back to the diversity, find out where we're at and maybe if we're missing in a certain category, if we need to be
So we just
marketing
need to
better.
add this to a report so you can see
What
male,
the-
female.
Diversity, with the diversity
Veteran.
background.
We can add
Right.
a tab.
Yes.
So I have another question, attachment B. So as of June 2017, we have 223 delinquent licenses. Can you talk to me about what that means?
That's for the whole fiscal year. That's not going to just be for the last quarter. And
Okay.
that could be licensees that are not wanting to renew. So after 3 years, it'll cancel automatically. So if they're wanting to do that, we wouldn't do anything to the system. We just not renew their license.
Is there a way to parse that out so we can really get a sense of what that is?
Like by month?
Or just break it out by, because if, we don't want to assume that 223 people aren't interested in renewing, if some of it could be folks that we need to do some additional outreach to get them to renew.
So if it's a retirement or if it's, whatever,
Or something.
right.
Because I don't want us to miss people that should be renewing because we don't know who they are.
They'll get delinquent renewal notices 30 days after the expiration, and then after 90 days, they get another one saying you have penalty fees. So renew right away because right now you're delinquent. But I can definitely look into how to distinguish the difference between retired.
Yeah, I think
or
that would be
canceled.
helpful. Or just add a footnote or something to give us a better idea of what this 223 represents. And then I think it would also be helpful to see what the representative sample is. So I know we're seeing it as a snapshot in time for the quarter, but how many renewals do we need? Because the renewals and then the licenses, that helps to sustain us. So we're just trying to make sure we're getting enough renewals to sustain the board. Okay.
It is a little confusing too, because these numbers are for April to June, but since the renewals go out 3 months before expiration, somebody in December might renew early, so it looks like in April to June there was more renewals than that were sent. That's just because the renewals go out 3 months in advance. That makes sense.
I mean, it may be helpful to see the quarter and then the year to date across the months.
Yeah, I agree. If we could see a breakdown, maybe there's a pattern that we're not seeing right now.
I agree.
All right, any other comments for Ms. Damian?
I have one question. When you say that there's 27 incomplete, the incomplete ones and the complete ones. So when you gather all the information, what information, I guess, from the Federation of Podiatric Medical Boards do you get that is part of the information you're trying to collect?
The Part 3 results,
Yeah.
and their disciplinary data bank.
Yeah.
I get those electronically, so those are
Those
really
are
quick.
instantly.
Yeah.
So that's their background check and their Part 3.
The background check's going to come from Department of Justice. The Part 3 and disciplinary data bank comes from Federation.
Okay. Because I know they're trying to expand their scope. So that's why I was asking. The disciplinary reports to state boards.
I usually get those at the same time that they request their Part 3.
You got it. Okay.
And I have another question. Can you explain how attachment C relates to attachment A? Because there was a comment about the 27 incomplete licenses that could include some resident licenses.
Attachment C is just the number of first, second, and third year residents. So it's just saying that there's 39 who are in their first year, 41 that are in their second, and 41 that are in their third.
For clarification,
Nothing with
in the first and
permanent
second
licenses.
year, they can't apply for a license. They haven't finished 2 years.
Okay.
The third years, some of the 41 in the third year
Could be a part of that
could be
27.
applying for licensure.
And then is it possible to see a year-over-year comparison of this as well?
Of the residents?
Yeah.
Yeah, I can do that.
And back to the attachment A, is it possible to figure out who that 27 is? And if they do include some third-year residents who've started an application but haven't completed it?
Of the permanent license count?
Yeah, because at the bottom you have initial license application, there's 27 that are incomplete.
So you want to know which ones are current third year residents applying?
Yeah, I
for
mean, it may be helpful to know
Okay.
if there's additional follow-up that needs to happen on an application. I think it's just helpful for us to kind of get a better understanding of what the numbers mean. Yeah. That's all my questions.
Thank you.
Anything else? Okay, well, officially, thank you very much for your report. Next, we're going to enforcement. Ms. DeAngelis.
Good morning. Before I begin the enforcement report, I just wanted to comment, that'd be a good time to mention that the department has started a new program, and some of the issues that a team has been put together and tasked with is to identify barriers to licensing and also to address outreach. So this is something we've just begun, but it is something that we'll be working on for the next 7 months and probably ongoing. Any ideas or suggestions that you guys have that you want to bring to me that I can bring to the team would be welcome and appreciated.
I think it would be helpful to have maybe a presentation on it because I'm not quite clear on what it is.
This is part of Bethany's Future Leadership Development Academy. And I think one of the projects they're going to be working on as a DCA department as a whole is the difficulties of providing outreach to different boards and bureaus.
And the
So-
reason why I mention it is just because that's come up a lot at our board meetings and as concerns. So I just wanted to make you guys aware. Any feedback that you would have, barriers that you notice that you wanted to bring forward that we could work on as a team, as a department.
And I'm fairly new. What is the Leadership Academy that you're?
It's a brand new program that's being
Okay.
developed through DCA.
Oh, okay.
So
Wonderful.
get mentorship through seasoned individuals and
There was 80 applicants that put in for the Future Leadership Academy, and out of the 80, 12 were chose, and part of the 12 students, Bethany was one of the individuals. So a very big accomplishment.
Congratulations. Congratulations.
thank you.
So Bethany, this is communication between boards?
Yes,
Okay.
because we're all have the same mission. We're all trying to accomplish the same thing, and we have to work within DCA. Many of the boards are using Division of Investigation, the Attorney General's office, administrative services, other services that DCA offers. So this is increasing communication between DCA exec, the boards and bureaus, and to help us all put our minds together and come up with ways to address the individual issues that we all have, all of the boards and bureaus face.
So is it more ideas on like how the boards function individually and maybe share that kind of information? Or is it more along the lines of the frustrations that boards may have, or?
Probably all of the
Oh.
above. Knowledge sharing, just pulling together ideas and techniques and ways that we can address the individual boards and bureaus, I guess, problems or areas of concern or where we want to work on.
One of the biggest things here in outreach with DCA and having this effort with all the boards is, number one, it would be networking, and then above that is cost savings. So the more network we can do with the other boards and bureaus and have that consistent message, then there will be cost savings. So I think that's one of the goals that they're trying to accomplish, and a very difficult task at hand too.
Have they ever had like a meeting where they would have a day here maybe that all these boards would actually get together under one roof?
We do regularly get together to discuss various things, and different people in the department get together. Sorry to deviate from the report, but I thought it was a good time because of the licensing concerns and outreach concerns that are brought up. And just wanted to let you guys know that that is something the department's working hard to address.
Well, absolutely. One of the things working in government, I completely understand, is everybody works in their silos. And so some of the procedures are completely done differently in one division than on the other when they almost identically match. So I would love to hear best practices next time, maybe a report on what other boards are doing as well. Thank you.
Absolutely. Keeping that communication between everyone, we can find the best practices, the most efficient, workflow to support what we're trying to do.
Yes, thank you.
Okay, so with that, I'll go ahead and get into the enforcement statistical and program updates. We're continuing to see, if you look at attachment A, the complaint data, the complaints have increased a bit, but we are still within the target of 9-day for complaint initiation and assignment. Attachment B goes into the investigation data. Again, we're seeing additional investigations open because of the additional complaints, but the processing time has actually gone down quite a bit. Much of that is with the desk investigation phase. Most of them are closed at that level, but also even with the difficulties DFI is experiencing, we're seeing better closing rates or closing times on those field investigative cases as well.
I have a question. With the complaints, being that we're seeing an increase, are we seeing any trends in the types of complaints? And is that an opportunity to maybe reach out and address some challenges that doctors may be facing?
I've been thinking about why we might be seeing an increase and haven't actually had a chance to go through and pour through, all of the individual data. But I do know that with the transfer over to the Breeze system, some procedural changes have occurred. For instance, when we send a probationer to the AG's office for violations of probation, we were opening 2 cases and then relating them together when it really only needed to be, one complaint. So these are processes that are being refined over time. We're now dropping that down to just opening 1 complaint instead of 2. So also, if I take action on a non-compliant probationer, which I have been doing more of the past couple of years, that's a new complaint. If I do a citation and fine for someone, that's a new complaint. So occasionally we get duplicate complaints coming from different sources. So it's the same individual, but the same problem they're complaining about. And those really what I'm seeing. I don't think it's a great increase in bad doctors. If you look at the statistics back in 2008, when the probation program transferred from medical board to our board, there were 35 probationers, and at this time we have 14. So that's actually looking pretty good as far as the number of doctors that are undergoing discipline at this time.
So are these complaints that come in through phone, email, or how are they
Come
taken?
in anyway. I think the majority of people, and again, I haven't been tracking this. This might be something medical board does because the complaints are first sent to medical board, and we have a consumer complaint analyst there that processes them for us. Then they come through our board for review, and I'm more involved at the investigation and disciplinary levels, and after that, probationers. But yeah, they come in through online, through the written form, sometimes through an email, and then we'll open a complaint based on that. They also can come in through the phone.
The board members may not know this. In MD and DO offices, they're required to post a
I
notice
was going to ask that.
with a complaint and phone number for the medical board, but that's not a requirement in the podiatry office.
So that was going to be my next question. How are we informing the public about the process to file a complaint? Are we including that in like the newsletter? Because I don't want us to not get complaints because people don't know how to file a complaint. So is that something we need to look into where it's mandatory for our licensees to post that in their offices? And then how will we check to make sure that that is truly happening?
I believe that there may be in this new legislation some language that has to do with posting, and I'm not sure, but I think they just included podiatric medicine in that. Kathy may know better.
So is that something we can check into?
Yeah, it's definitely, we can check into that and try to tighten that up a little bit.
And maybe in the next newsletter, we can put something just to inform people of the process. Because, I mean, this is for the public, so we need them to know.
We can do the newsletter and also the website as
Okay.
well.
Perfect. Thank you.
We've definitely been thinking of ways that we could revamp certain forms and the newsletter, the website, and try to get more information out there. So.
And then the next question is, so if someone wants to file a complaint, is there a special email address where that complaint goes to? Have we fleshed that process out as well, just to make sure it's easy and streamlined so people...
So it's a online complaint form, or they can come into the office. It's through the Medical Board of California. We use their complaint form since they're processing them. From our website, there's a link to the medical board's site and to the complaint access. It gives instructions in the form there where they can submit that online.
So will that change with the new legislation? Have we thought that through?
At this point, between our conversations with the medical board, there should be no change to the process. There
Yeah,
may be
that's
slight
correct. There is
changes
no
to
change.
the forms themselves, or names on the forms, but the process won't be changing.
Okay.
Okay. Any questions on the investigative?
I do have a question. So the statement, dust investigation processing has dropped by 57%. Do we have any indication as to why?
I truly believe that it's, most of this can be attributed to Julie Brown, our desk analyst. Like I said, most complaints get closed at the desk investigation phase and don't go forward into field investigation. So her quick processing time of turning those around has really helped our numbers there.
Also, it's the processing time has dropped.
Maybe I misunderstood your question.
Because the statement says desk investigation processing dropped 57%. So it's the time to process has decreased?
Yes, the average days to complete investigations has gone down 57% for
Okay.
desk investigations.
So we may want to revert that because it makes it seem like they've stopped processing our desk
Oh,
investigations.
sorry about that. Yeah, if you look at attachment B in the under the desk investigations, and over in that last box, it says average days to complete investigations, Q4 total is 50 for this last quarter of April through June, and last year was at 116 days, so that's the 57% decrease in processing time.
So she has a new process? Is that what it is?
I don't think it's a new process. I think it's just able to get them turned around. When she first started, there was a 6-month backlog that needed to be caught up, and now she's there, and so it's easier to stay caught up and on top of the workload.
And Julie's in the back there. Julie, can you wave your hand? Thank you for all your hard work on that.
Yeah, she does a great job for us. Any further questions? I will go to the disciplinary data. We had 3 new cases during the Q4. That was a 40% decrease over last year's Q4 when there were 5 cases. 3 final orders went into effect during that quarter, taking an average of 998 days. This is an increase over last year when 2 orders took an average of 665 days to finish. The days to process AG cases really fluctuate, so it's kind of hard to do too much of a comparison unless you put several years together. We have so few cases that the stats are going to, really vary. I do want to let you know, and this is not in the report, that we've had a really big influx of cases lately from the AG's office. In the next probably 6 weeks, expect to receive as many, if not more, cases for review than you normally receive in a year. So they are about to be processed and will be on their way. No citations were issued during the Q4. We had 2 new probationers added. No completions, but I did submit 1 case for violation of probation to the AG's office, and there was 1 petition to revoke probation filed by the AG. And at this time, we have 14 active probationers.
So I have a question on the cases. How much lead time do you get to know when cases are being closed? It just kind of concerns me that we're going to get an influx and we really have a short turnaround time to get them reviewed. So is there any way for us to get a heads up? I mean, you're giving it to us now, but I'm saying, is there some sort of trajectory of these cases and a timing so that we can plan for that? 'Cause
Unfortunately, I don't know if it's just in the air in the universe right now. Everybody just seems to be really busy, and there's a lot of work coming through at this time. These cases just all seem to finalize around the same time. Settlement conferences were occurring around the same time, so they just happen to all be closing close together. I am working with the investigators and DAGs as cases are in process. And so I am kind of aware of where they are in the process. But as far as closing, there's, besides, when they schedule the settlement conference, there really isn't a way to project exactly when that case is going to be completed or settled.
I just wonder if there's a way to work with the AG's office to kind of create some sort of flow.
I know Gloria Castro should be here soon to be able to
Gloria's here
report.
now.
Oh, she is here?
Hi, Gloria.
Would you like to give your report this time? Is that okay?
Well,
Might be good timing.
I am so sorry that the vacation, let's go. They don't listen to me.
Better to make it here alive
Yes.
and late.
It was fine. I'm happy to come up and do that right now, Bethany. It's up to you.
It's up to the board if they would, since we're at the disciplinary portion, if you'd like to hear from the AG at this time.
Please, if you could hold up on your report for a minute, Ms. Cashman.
Okay. I will
Then we
do
have
so.
Karen here as well for budgets, right? Yeah, there you are. Okay.
Good morning.
Good morning.
I'm Gloria Castro. It's my pleasure to lead the Health Quality Enforcement Section, a unit of 60 attorneys located in 5 cities statewide, representing your honorable profession in licensing matters, investigations, and administrative actions. As your legal counsel in judicial and administrative proceedings concerning disciplinary matters, over doctors of podiatric medicine, you perform obviously a very critical function of the state government. And performance metrics is at the top of our list of concerns. How quickly do we get from point A to point B to point C and on to ultimately for that licensee to come before you for a final determination? The evidentiary burdens are very high. The harder it is to obtain a license, the more difficult it is to remove that license. At the same time, we help make certain licensing matters also come to fruition. When we see licensees or applicants that are trying to get into your profession, from time to time we have to file statement of issues cases against them. We handle those as well. We operate your cases under what is called a vertical enforcement model. It is a very good model to be able to triage cases for disciplinary action, especially to the extent they involve a highly dangerous physician or some other issues such as mental incapacity and practitioner self-abuse of medications or their prescribing privileges. This direction authority is critical, and it is done in conjunction with Department of Investigations and their Health Quality Investigations Unit. Within that context, we make legal recommendations and recommend to our executive officer whether or not an accusation should be filed, an interim suspension order, a mental or health examination, and from time to time, Penal Code Section 23 actions in criminal proceedings. Those are highly rare, but those are bail recommendations. And at the same time, we do, because we're involved in the vertical enforcement of your investigations, we do make assessments and work very closely with Mr. DeAngelis on whether or not to close a case due to a lack of evidence or not being able to meet the applicable burden of proof. Other times, we do make recommendations for other types of outcomes that are short of outright discipline, but help to rehabilitate the licensee. And so as your attorneys in these disciplinary matters, we hold these obligations in the highest regard, and we uphold our ethical obligations to you. And we have a fierce commitment to protecting the public on your behalf and maintaining the quality of your honorable profession. Our 60 attorneys seek to provide you with the highest quality legal services, and they're very, very passionate about what it is that they do on your behalf. Under the leadership of Mr. Noslin, this commitment continues in the sense that we work closely with Bethany DeAngelis and the rest of your staff. We have assigned a liaison who you heard from at our last meeting. She was incredibly sick, and she still wanted to be able to participate in your expert training, and it is one of her favorite activities to do. And expert training is something that we have a high commitment to, because without experts reviewing your cases, there will be no discipline whatsoever. And we understand that it is a very small profession, and even more so is there an importance to be able to maintain the quality of the expert review so that your outcomes are as even as possible, even though each licensee is weighed on his or her own merits, education, qualifications, and duties, and the specific facts of the presented case. I wanted to jump into SB 467, but I wanted to know if there was any questions about what it is that we do on your behalf at this point. Okay. Effective January 1st, 2018, the legislature will be receiving reports that we file concerning your cases and our management of them. And these points will be made public. And before we do that, I'll make sure and be able to give you a pre-show. Because some of these metrics that we are having to report are actually metrics that this board owns. How many cases you file per year, how many you withdraw, how many you dismiss, and also averages. How quickly do we file cases? How quickly do we present stipulations to you? So some of them are performance metrics of the board. Others are performance metrics of how quickly the Office of Administrative Hearings sets your cases. And a few of them really do reflect how quickly we do our work. And this is supposed to be able to help all the 4 actors that are involved in your enforcement process to work more cohesively and hopefully present ultimately a ruler by which all 4 of those entities are measured. The 4 entities are, of course, this board. You see the cases at the beginning and at the end and throughout in the middle when we're making very critical decisions such as settlement offers. The investigators have a very big part of that, and there are those timelines that they have to manage your cases. The Office of Administrative Hearings also is an actor in this, in that they are the ones that decide whether to continue a hearing or not, and how quickly they set a case for hearing, and how their calendar is impacted with, sometimes these hearings can be 5 days to 2 weeks. They're not simple hearings, and many times our licensees are in the fight of their lives, and they are entitled to due process. And then fourth, that's our office. We handle some of those timelines as well, and we are responsible over them. So SB 467, like I said, it's taking an accounting of certain things that you did in the past fiscal year. So how many of these things did they do, these boards? And importantly, the average number of days between when the Attorney General receives an accusation referral to when you file an accusation, and so on and so forth. The SB 467 is only going to track accusations. As you know, accusation matters are what I already basically gave you a little preview of. Those are the most serious types of matters that we file against licensees, and they're entitled to a high evidentiary burden. They lead to administrative proceedings that revoke or suspend a license or place a licensee on probation. It's meant to protect the public from dishonest, immoral, and disreputable or incompetent practitioners. But the intent is always to rehabilitate and not punish the individual. But where public protection is inconsistent with rehabilitation, this board takes whatever action is needed. I think it's important to realize that the Consumer Protection Enforcement Initiative of 2010, which put 540 days from nose to tail for every single board and vocation department under Department of Consumer Affairs. 540 days is a marker that you have been able to meet. That is performance metric number 4 for us, that's AG time. And we hope we're poised to have you meet that performance metric again. And the 540 days applies notwithstanding whether someone is a professional or a vocation or a business. And please understand that professionals are entitled to a very, very high standard. It's called clear and convincing to a reasonable certainty. It's one step below the criminal, like beyond a reasonable doubt. Whereas some vocations actually have a preponderance of the evidence standard. It's a vocation. So like we say, the longer it takes you to get your license as a professional, the higher the burden it is to remove it. And it makes sense. It's something I don't disagree with. I'm a licensed professional as well, being a lawyer. We have always strived to have internal performance metrics that we strive to meet internally. We try to file cases within 30 days of receipt. Within 10 days of receiving any case from any client, we make a decision whether to review and reject it, review and return it for further investigation, or go ahead and accept it for prosecution. I am pleased to say that we do not reject or review or return any of your cases because they're all vertically enforced. They're not handed off. They are cases we have seen before and are intimately aware of. So that's a metric that you should be proud of. At the same time, our pleading turnaround time is at about 58 calendar days, which works out to about 32 working days. We can improve that, hopefully, but we're always striving to improve that. The way we see the pleading sent metric is that the sooner we put a patient on notice that their podiatrist may or may not have some practice issues, the sooner that patient can make an informed decision as to whether or not to maintain the relationship with the podiatrist. Many patients will continue with their podiatrist, but it should be something that they're aware of. We know that we have heard a lot of discussion in other boards on probation notification and whether or not patients are aware that their practitioner is on probation or not. But we do believe that putting the accusation before the public is of utmost importance. Because the health quality enforcement section is created by statute, it's one of the few sections in the Attorney General's office that is, we have 100% healthcare oversight agency clients. And so we do not deal with vocational licensees. We have a highly trained staff who is very aware of different quality of care issues and very committed. We have about 11 clients at the moment. That may increase in the future. I want to also say that our Attorney General, Javier Becerra, has made it a top priority of his office to maintain the health access and maintain the health care quality in California in light of all the challenges that we face. He is very involved in our section and very, very committed to our work and to getting us the resources that we need to be able to perform as excellently as possible and efficiently. There is a balance between quality of outcomes and time, and it's always that balance of, and as podiatrists working in an HMO, it's always like, okay, we have only this much time, how much can I spend in a day to perform this activity? So we're always having that discussion internally on how to make things better and quicker and maintain the high level of excellence that you expect from our office. And so with that, I wanted to describe to you some of the reports that we have been providing to our client executive office. Probably since at least 2012, we have produced these reports, and more recently, we're producing more reports that show what is pending at our office, what cases are set to be heard, what cases we're triaging for possible defaults. Currently, you have about 11 accusations pending against licensees. You have one statement of issue case and one penalty reduction case. And at the same time, you have, in terms of investigations, you have 41 open investigations, but 4 of those investigations are actually for one individual. So, minus, can't do the math off the top of my head, but you have about 41 pending investigation matters. There has been some impact due to the fact that HKU has some vacancy issues, and that is being reflected in some of the aging timelines that we're seeing with the vertically enforced cases. And with that, I will conclude and be open to questions. I did walk in halfway through a question, and that's why I ran up here. Or
Yeah.
I can bring Miss Angeles back up.
So the question was, how can we get a little bit more information or lead time about cases that are closing?
Yes.
Ms. DeAngelis mentioned that board beyond notice, you're going to get a lot of cases. So I'm just trying to get a sense of, how we can
Yes.
plan, because this isn't our full-time job.
Mm-hmm.
So, just being mindful of, we want to be mindful and responsive. So it would help for us to kind of know what could be coming down the pike and when.
Yes. And so this board is responsible for taking votes on stipulations.
Yes.
calling us here if you want more information. All of our staff is available to come in here and explain to you a stipulation. That would be obviously in closed session. I don't think it would be a challenge to be able to inform Ms. DeAngelis on a quarterly basis if we know what your schedule's like and how many weeks from your board meeting you need lead time to decide. I think it is very important to look at that because if this board does not act, decisions will be adopted as a matter of law. And this applies to Office of Administrative Hearing outcomes that are proposed decisions, and you have within your discretion and jurisdiction to non-adopt and obtain more information, hear the case anew. You have a lot of options.
And I also think it would be helpful, because we do have a lot of new board members, is to maybe do some sort of training on the review of the cases. I mean, sometimes, if you don't have that legalese or haven't had that experience, and because this is such an important part of our jobs, I think it would be helpful to have, maybe some sort of training.
Yes.
I don't know how that can work, but I know I would appreciate that, just being able to walk through what we're looking at and what our options are.
And I would be more than happy to do that, as would Emily. We would like to be able to explain to you why, and I know it's always, why does it take so long? And that's a fair question. And to be able to explain the process and the investigation and the administrative. And we have flow charts and PowerPoints, and we're very, very open and willing to come in here and do that. And I like to attend because I do like to have our liaisons go ahead and present that. But from time to time, the board actually has questions that I can answer the best. So we're happy to come to your next board meeting, whenever that is. It's a very, very important question. And the more that the boards understand it, the better the public understands it, because the public does interface with you. They're all interested parties, they're all stakeholders, and especially your colleagues and licensees, fellow licensees.
I actually agree with Mrs. Dixon on definitely would love to get more training. I am the newbie on the board as well. I would love to see it maybe in a workshop form,
Yes.
where we can actually sit down together and actually go through some questions and maybe feed off of each other.
Absolutely.
If we could do that, that would be absolutely beneficial.
And we would welcome any criticism or questions or offers for improvement of the process. While it is always our goal to, I'm looking for my chart, but I'll stop looking for it because I wanted to just maybe give it to you to copy for them, but I'll give it to Bethany. Yes, we're very committed to that.
Yeah, we can try to squeeze it in there.
We need about 45 minutes.
45 minutes, okay. In a workshop, so yeah, we could probably do that.
And by workshop, you mean like we would present here, the board sits back there, and we
Right, a little more
present it.
interactive, right?
Good.
A little more hands-on interactive.
Yes.
Okay,
Yeah.
I
we
have,
could do that.
I have a question.
Yes.
Since Breeze came online, do you see maybe that's generating automatically some of the complaints?
Oh, yes.
And that we're kind of now, and would that explain maybe this sudden increase,
Yes. Yes, I think across all, we have 11 clients in HQE, so I only speak for my clients, but I'm sure if you had the senior assistant from licensing, she would probably say the same. We've seen a really huge increase in the amount of access that the public has to file complaints. Sometimes, regrettably, the complaints are sent to the wrong client agency, and then some work is expended to, shepherd it to the correct client agency or to the ultimate authority that would have jurisdiction over that issue. But at the same time, I think that the webcasting of meetings has made access a little bit more easier for our patients to be able to see what's going on, understand how this board uses the licensing fees of your board. And while these are fees that are paid for by licensees, once it goes through a pass-through through the board, it is government money and it is for the benefit of the public. I think that it is always something that we would like to see more of is more education on consumers and the ability to file a complaint. And the accessibility of the state government employees that work both at our office and here with the Board of Podiatry and the executive officers is top notch. We pick up our phones. They know our faces and they do get to talk to a real person. We welcome that. I think that the more that patients understand, the less unhappy they are with the process, or at least they'll understand it. They may not be, they'll understand that it's a fair process. And I think ultimately that is part of transparency and accountability. And from time to time, patients do point out, like, well, you know what, I wish I would have known that what the outcome was. And that's something that's solvable. Sometimes patients on whose behalf we file complaints don't end up finding out what happened. We do try to send closing letters to patients saying, thank you so much for bringing this complaint to our attention. If it had been for people like you, we wouldn't have been able to better this professional's skills. So, yes.
So a question on that. The responsibility to close the loop with the initial complaint, is that on the board or is that on the AG?
It's on the board, but when we call our patients to testify, we always send the decision in order of the board, and then we thank them for their time. To bring a patient back to relive a very bad day or a bad series of events in their care is to traumatize them again. So we understand what we've put them through, and they get no money from us, that they're not getting compensated. As a matter of fact, they're being inconvenienced, even though we pay, very, very small, parking, we'll pay for their parking and their mileage and things like that, but that doesn't cover taking somebody out of work or whatever it is that they're taking care of their kids. So I think that is an important part of the process, that puts a nice closing thing. Not only that they can complain, but they find out what happened.
So will that happen more frequently? Is that what the goal we're working towards, is to make sure that that happens?
It was a suggestion that I'm making.
Okay.
Mhm.
So can we take her? I mean, I think that's important for the public, for them to know that we've done our due diligence on their case.
And we'd be happy to help with that.
Okay.
We only do it right now for our hearings and if they testify. But sometimes we do hear from patients after the fact, like, hey,
Right.
whatever happened to that? And I think on closed investigations, patients do get notified, like, hey, thank you very much. We did receive your complaint and we closed it. They may not be able to find out more than what we tell them, but at least they know that we finished.
And I think it would be
looked at it.
helpful for the board to see that kind of
Mhm.
communication from, a complainant. I think we see it in various stages, but we never hear about
Tail
that,
end.
right? So I think that's important too.
Mhm.
Yeah.
And on stipulations, that's definitely another part of the process that we do not notify patients of. So we just have very little time to do it, but if we were directed to do it, we would endeavor to do it.
So the board has to direct you to do that?
We've always assumed the board sends a closing letter, right?
So can we find out about that, Brian?
Yeah, we'll definitely will.
Okay, thank you.
Any more in your report?
No.
Any more questions?
I
Thank
will
you
see you in
very much.
December. No,
See you in
thank you.
December.
Thank you very much, and I apologize again for
Well, thank you,
the leaky
Gloria.
wing on Southwest this morning.
Well, hopefully your flight is no
Yeah, we
no
want that.
leaks.
Hopefully it's not uneventful on the way back.
We want it fixed before we fly home.
Thank you.
Take the train.
All right, Andrea.
And just a comment, there are closing letters that are sent to complainants at the end of a case, and medical board handles those for us, whether it's at the desk investigation phase, field investigation. There's a new position that was created from D of I that's housed within medical board that closes those field investigative cases for us. And with the AG, I have not checked with the individual that processes those cases. I imagine that when it's discipline, it's even more important to get a closing letter out so the complainant knows, but I can check on that to verify and possibly provide samples of the
Would-
letters that go out.
Would the enforcement committee be interested in looking at those letters
Yeah, I'd like to see it.
and seeing what the outcomes are of these cases? Would that be possible?
Yes.
The enforcement committee member, one of which is here, yes. I'm sure Dr. Manzador would appreciate that as well. So yes, we would. Thank you.
Okay, I can gather those and provide them at the next committee meeting.
Thank you.
One more comment on the AG cases. It's very unusual, the number of cases we have all at the same time right now. So I don't think it's going to be like a trend.
It's going to be a what?
I don't think it's going to be a trend that we're going to be seeing this many cases ongoing. Out of the 12 cases that are mentioned on, I believe, attachment E, that are with the Attorney General's office, there are 8 cases that are now pending closure out of those. So that's going to drop our numbers down quite a bit once they close as far as pending cases there. And within the next couple of months, those should be completed and you'll be seeing those.
How many are expecting?
I've got about 8 right now that are in some sort of process and waiting to be go through the process and be sent to you guys for vote. 2 of these were ALJ decisions that just completed. Others, settlement conferences that were just completed.
So the question is, when those cases, because usually it's a 1 to, I think, I'm trying to think of the time, the turnaround time. So who determines that?
What I could possibly do is kind of piecemeal them out. I mean, it will affect our time frame as far as when the case closes, but I can try and get them, 1 a week, work with our discipline analyst who processes those, and she actually returns from a 2-week vacation next week, so I'm sure she'll be catching up anyways, and try and see maybe which ones have the highest priority, get those first, and so that way you guys aren't overwhelmed.
Yeah, we would just appreciate the thoughtfulness of the cases coming our way.
Yeah, because I do know there is a turnaround time that you guys have to provide a response to vote on those cases, so,
Yeah,
okay,
thank you.
I can definitely do that. Moving on, attachment D shows the entire fiscal year compared to the prior fiscal year and where we stand. Again, we're looking at the overall, a little bit of increase in complaints and investigations, but our time frames are lessening in those areas. And we're seeing the increase in the cases initiated with the AG as well. Accusations filed and final orders have gone up a little. Again, I think that next year we're going to see a little spike in the AG case closures, but I don't know ongoing if that's going to continue, or we're just going to have one really active year. Nothing else notable for the entire year unless you guys have questions on any of that data. Okay, the case aging, attachment E, I covered a little. We had 3 new cases initiated this last quarter. Shows 12 cases pending. One of those on that chart does show that a stipulation has been signed. It's just not fully processed yet and closed. I've included this time attachment F, which shows the complaints received since we implemented our continuing competence program. This is the additional requirements through licensure renewal. In addition to the CMEs, they have to complete one of a variety of pathways. And we can see that the complaints have dropped over the years. We're seeing a slight increase lately. Again, this could be what Gloria mentioned as the increase to the public of the availability to make complaints, as well as system changes and the processes internally. So we'll have to see what happens over the next couple of years and determine what where we're trending there with numbers of complaints. Attachment G is just the DCA publication of performance measures for quarter 3. Quarter 4 is not yet available. That's just been included for your review. And that is it on my statistics. If you have any further questions on statistics.
Thank you. Are there any more comments, questions?
I have a quick question, once again about Breeze. So if in the past a consumer, makes a complaint because of something either that was done to them or whatever, that's one thing. But with the now availability to quickly see if you have an overprescribing physician, that complaint would necessarily be from a consumer, correct? And where is that complaint? Would that show up in this lump of complaints? Do you see what I'm saying?
Are you talking about maybe an internally generated complaint based on a Cures report? Or?
Sure.
Have we had any Cures complaints?
We sometimes receive a complaint and we'll run a Cures report on that complaint depending on what the complaint is about. If it's about prescribing.
But has Cures themselves generated a report of a overprescriber?
I have not, yeah.
So the Attorney General's office manages the Cures database. And prophylactically, what should occur is if there's a complaint, usually but from pharmacists, sometimes fellow folks that are in the profession and file anonymous complaints, and sometimes patients. If a patient is being overprescribed medication and is something that is welcomed, notwithstanding it's very injurious to their health, we oftentimes don't see patients filing those. Maybe family members that are concerned that their loved ones are being over-medicated. But prophylactically, what we would do in a vertical enforcement model is go ahead and run a Cures report. We would run it for a very, very specific amount of time. It's not like it's not like a huge amount of time. It's what we can reach within that statute of limitations. Then we would show this to an expert, and then that expert would determine, for them, what type of surgery is this podiatrist doing? I mean, there's enough medication here to anesthetize an elephant. They may pick out other patients that never complained. No, those complaints would not be captured in that one number. And I think that's something that the public sometimes maybe doesn't understand is like if a patient files a complaint, once they're in, they're going to be looked at holistically and prophylactically within the confines of the law and within the confines of our discretion, just to make sure. And sometimes we look at the Cures and there's nothing there. They're perfectly just prescribing what appear to be post-operative regimens of pain management prescriptions or titrating or something where you just see that it's just not an abusive practice. Then we move on. That's a pure quality of care case, and the public can rest assured that the Cures has performed its function, which is to assist law enforcement and healthcare oversight agencies such as this board to ensure the safety of the public in face of these dangerous drugs and prescribing abuses of the privilege.
So those are all part of an investigation. Is there any
Yes.
algorithm in the Cures database? I mean, if the doctor doesn't complain and the patient doesn't complain and the pharmacy doesn't complain, anything ever get kicked out?
The system can self-identify within certain parameters that are given to it.
Can or does?
It can.
But
It doesn't because of resource issues and some upgrades that need to occur to it. Prospectively, that is the promise of it, that we could potentially look into the system and figure out what is the number one prescribed drug in this county or for this zip code. It's been subject to a lot of interest because it does involve patients that had nothing to do with anybody. They're just kind of in, all of us might be innocently sitting on a database. And so the government takes it very, very seriously on how this tool is used. It is a healthcare tool, but it is also a law enforcement tool. We had a big California Supreme Court case called Lewis, and our ability to be able to, on your behalf, look at cures was supported by the California Supreme Court. It is a lawful exercise of your authority as a healthcare oversight agency. But I can certainly speak with Mr. Nosland and bring that person from DOJ, from our cures unit, to help to explain what the system can do and how it does it. And if it's of interest to you, then it's something that we could look into on your behalf. It's not something we're doing right now. We're complaint driven.
So there's no other medical specialties that have said to cures, we could use this almost as a self-policing reporting thing, because I mean, if you had a physician in the community of any surgical specialty or not surgical specialty that was overprescribing opioids, say, this certainly, you could certainly pick it up here, and you could have someone review it and say, well, yes or no, But so my question, I guess, to you is that that's not being used in that way at all.
It's being used in that way with,
Someone generates a complaint,
right. If a
but not
complaint-
necessarily from a board that wants to keep an eye on.
Right. To my knowledge, the folks that are using it exactly like that are researchers, and they get de-identified data, and they are able to see that. Certain law enforcement folks that have very, very specific inquiries in mind, not specific to the licensee, but rather to how a certain drug is being prescribed in a particular way in a county, will have an interest to do that. The closest that we would be able to do that is if a board became aware of something that is a pattern and practice of abuse, then I could definitely see a board wanting to see, okay, we got this complaint, or we're aware that there's a pattern of abuse of this in our profession. It would be something to bring to your executive officer, and then it would be a self-generating complaint, which this board can certainly do. I think the resources are such that most boards and folks that assist you, we have so much work with what we have. But it is totally something that you can explore.
Yeah, that was going to be my question around how can a board help the system to do more? And is that a directive? I mean, not necessarily a directive, but a request of a board. So if, like you were saying, if we wanted to go that route, then we would make the request of the AG to
We would
generate a
bring that-
report.
We would bring that person here to have a discussion of what the limits are and what DOJ can and can't do with the data. But as a healthcare oversight agency,
We have
it is
that.
a tool.
Could,
that
could
you
we make a request, say, could we get the list of podiatrists that have prescribed more than 200 opioids in a year?
That's exactly what the system can do.
I have a question. Let's just say we wanted to do a audit of purely as a not as a research piece of information. The opioid opioid prescribing patterns of the licensed podiatrists in the state of California.
That's something that the system can do. PDMPs, the prescription dispensing programs, we're one of 40 throughout the country. I think we're one of the best. There are a lot of metrics that could be spilled out from that. And you're not the only ones interested in this. I think insurers would be highly interested in how many of these drugs they pay out that are actually probably not salubrious to begin with, and create another problem that the insurer will have to address, such as addiction. And that's not to say all the other social ills that come from abuse of these medications. So, yeah, I'm happy to, the person who heads up that department is retiring at the end of October. As soon as I find out who the replacement will be, I will let Mr. Noslin know. And it would be a meeting, and they can come and make a presentation to you. That is something we do all of the time. We recently were in front of the Board of Pharmacy giving such a presentation on, well, look, this is what Cures 2.0 looks like. Right now, the big push has been to try and get every prescriber who has a DEA certificate to register. And to the extent they have a DEA certificate and don't want to use it, then they can just get rid of their DEA certificate and not register to Cures, and no problem there, because they'll still be able to prescribe everything else. They can prescribe antibiotics, things like that. But if you're prescribing, you need to be registered.
Is there a penalty for not,
There will be prospectively. Yes.
for sure, or is that
Yes.
future legislation?
It's in there, and it's an enforcement thing, but we're not there yet. There has been some technological barriers that needed to be surmounted. It's as simple as it's a solar practitioner that has a very, very old computer, and their browser was not compatible with everything that the Cures, because the registration is one thing, but the registration is the easy part. We want them to be able to access in real time, prior to prescription, what other medications this patient is receiving from other sources, whether they be doctors, PAs, etc., in addition to the podiatrist. It's of importance to find out the concomitant kind of like interactions with someone who's already on something else, maybe some other controlled substance that's not pain related, but that is something that this podiatrist needs to know. And at the same time, the podiatrist does want to engage in a relationship with the patient who should be telling you all the drugs and medications that they are on. But at the same time, some folks forget innocently enough and have prescriptions there that they don't think are important or what's being asked. And that podiatrist would be well served, especially before a surgery, to know what else they're on, medication wise, and that would show it. So they need to look at Cures before they dispense medications. But I think they've resolved that issue, and at some point it is going to be a punishment if you're not registered.
Yeah, it is mandatory. But because with an integrated medical record,
Yes.
that, I work for Kaiser, so I have that information at my fingertips. But I'm thinking from a best practice standpoint, and as a board that is looking at complaints, this is certainly something that reinforces our ability to police it by saying, well, that's not really best practice. And I also think that the prescribing practices this is kind of a timely issue, as you know, throughout all the medical schools and all the residency teaching programs and everything else, because, it's shifting from, you can't let a person leave the hospital unless they're telling you they're on one or two, of pain feeling, as opposed to, well, that they're kind of getting rid of that whole idea, which they think is what started people giving them so many opioids in the past. So I think you're saying that we could maybe approach somebody from Cures to get prescribing practices of the podiatrists in the state of California off the Cures website. Like, in other words,
It would show you the history, and it would only be the first step. That'll show you what was prescribed and dispensed, because the folks that put the data in are actually the pharmacists. But that's only the first part of the inquiry. You need the medical record in order to say this is not okay.
Legit or not, yes. Okay.
So it's a tool to get to the facts of what really happened, and maybe this person has bone cancer, and they're treating the foot, and right, I mean, maybe not, right? But we need to cross that with, only with the medical records. But it is an exciting time to be able to provide practitioners with real-time data at their fingertips, to the extent that they're technologically able, or that they work in a big healthcare network such as Kaiser, that kind of pre-packs it. So when you see the patient, these things have already been done, and they're on a screen and ready to go. It's good because it helps patients ultimately. It helps society as well. So,
Thank you.
yes.
Just
Any more questions for Ms. DeAngelis?
I did have a couple questions. On attachment G, I'm just wondering, with the target average days or the targets in general, who sets those targets? How are those targets set? And is there ever a process to revisit targets to make sure they're realistic? Especially if you've set a target and you're not meeting the target. In my experience, it may be time to revisit the target to make sure that it's realistic.
These targets are set by DCA. I have been at meetings before where they were discussed about revisiting them, but at that time, they decided to stay with the targets as is. I'm sure that they regularly review the information and targets and are looking at this. If they see a need to update, that would be coming. But the targets that were set when they initiated performance measures have not changed to date.
So is that something we can get more information on? And can we help inform targets? I mean, in my experience, if you're being held to a target that isn't realistic for your line of work and et cetera, it's almost, I mean, you're setting yourself up to fail every time.
These targets are the same targets across all the boards and bureaus at this time, so I know that we may have differing needs and timeframes depending on the licensees and how complicated the investigations are. It's definitely something I can look into, see where the department is as a whole on performance measures.
Do you find any of the targets inappropriate for what you're doing?
The case aging at the discipline phase does not seem to ever meet targets, or very rarely. I believe from the time the AG gets it until the case is closed, we're okay there. But the way DCA counts it is from the time the complaint is received until it closes. So it's including any field investigation time, any time that it's with the AG, and they can drag on sometimes for a while. So I would say that for our board, that time frame is looking a little unrealistic right now, what they have set. I don't know, with all of the changes and how the programs are evolving, we might be able to meet those closer to our target. It's just kind of a in process.
Have we done any sort of trend analysis to see, patterns of, I mean, I just think, and that may be something that the board can help inform DCA on. I just don't want us to be held to a target that's just unrealistic. So it may be helpful to see it over 4 or 5 years. If you've never met the target, I mean, I get that you want a universal target, but sometimes universal doesn't work. And we're being held to that standard. So if you're being held to a standard you can't meet, then it's not very helpful.
I can look over the last several years worth of data since when we began the performance measures and see how close we are on a year-by-year basis and provide that to the board.
But if we're missing it by the same amount, everybody else misses their target, and then we're not being singled out for a poor performance.
We're not
Everybody
in the
gets
spotlight
80%.
right now for how long it takes to complete a case. So I believe that many boards and bureaus are having the same issues of not meeting all of their performance measures.
And it's also a morale issue with employees because, you have a standard and that's the goal. And if you're not going to achieve it, then we're not giving you the tools to get there.
And certainly even if we're normal at 50% or 75%. If something were to happen and investigative reporter were to look at this, they'd say, well,
Exactly.
no wonder that problem wasn't caught. They're way below average.
Right, because this all is public information.
Well, let us do this. Let us dust this off and then start the discussion with DCA and see where we can go from there and try to get the analysis on the data.
And I think with that analysis, can we also see, to Dr. Zapp's point, a comparison to other boards?
Right.
Yeah.
That would be interesting to me as well.
Absolutely.
Okay.
That sounds like a great leadership project.
I imagine that DCA probably has some of these statistics already available, just I need to find the right person to ask.
Right.
And any more questions? Okay, so Bethany, thank you very much for the presentation. Before we
Haven't
move
finished.
on,
I'm sorry. That was just the stats.
and keep going.
The rest should go quickly unless you have a lot of questions. So probation program update. We've collected $24,314.43 this last quarter. Probably the highest quarter since I've been tracking this information the past 5 or 6 years. And our total for the fourth quarter was $87,189.83. I'm sorry, that was for the entire year, which the average for the past 5 years was $61,000. So we're doing really well with our cost recovery at this time.
I have a question on cost recovery. Do we have any sort of tracker of what we're expecting? Like, are we tracking receivables? And can we see that? I'm just asking because I know that when cases are closed, we say we must repay the board this amount of money. So are we tracking that to know what's coming in and, what's still owed, and then what's the follow-up on the what's still owed?
We have spreadsheets for each individual that still owes cost recovery or probation monitoring costs, and they are sent out annually, a new bill. Individuals that have owed for quite some time, we sometimes send them to, it's the FBI, I can't remember the name of the program right now, not the FBI, the Franchise Tax Board. And so they will try to obtain fees for us from tax returns. This time, I'm sorry, can you restate your question?
So what I would be interested in seeing is a receivables report, which tells me what's owed, and then what's been paid, and then what's still outstanding, and an aggregate. So I don't want to see it by individual. I would like to see it across for all the individuals for the case. You do know what I'm saying? For the cases that are closed.
Our annual report, and I work with the administration and budgets to put together a report to show what individuals were required to pay for the year, what we received, and outstanding amounts as well. So that is available if you'd like to review that.
Absolutely.
I just think it helps to add context, because when you have it, and I'm a finance person, so forgive me, but when I see we've collected 81,000, then my question becomes, well, how much was owed?
Yeah, we definitely can get you that information because we do have it.
Okay, thank you.
And maybe add to it if we could see how long the person owed. So is it, 1 to 2 years? Do we have people on the books for 20 years? That would be,
There's a really short list of individuals
Okay.
that still owe us money that are not under discipline. At this time, we do not allow individuals to get off of discipline without being fully compliant with their terms and conditions, so they
Okay.
have to pay. Otherwise, their probation is extended.
okay.
So that's, we're on top of that at this time. There's not very many that have outstanding long-term balances. Probationers do often enter into payment agreement plans, so they may take the full 3 to 5 years to pay off the full amount that of cost recovery that was
Okay.
ordered. But we make sure that they stick to that agreement, and if not, then we'll take action on that.
Okay, wonderful. Thank you.
And then my last question, when the costs are recovered, what does that go towards? So and I'm thinking accounting, forgive me, I'm a controller by day. So when the money comes in, what is it offsetting?
I believe it just goes into our fund condition, but that would be something Kathy could answer for you. It goes into our general fund?
It's a general
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 fund.
fund.
This goes back into our pool of.
So
funds.
offsetting the cost of the investigation, the closing of the case.
That's what the cost recovery is intended to do, is whatever costs were incurred during that investigation and the discipline phase, we put it back on the licensee to pay those back.
Right. So it's helping to inform or help us to be able to last longer, right? In essence. So so I'm just trying to get to the importance of recovering cost,
Right.
because as a board who depends on licensing fees to stay alive, if we've paid out money for a case, we need the person to pay back.
Right.
So we can keep doing our work to protect the public.
Yeah, we're small. We have a small budget, and so we're definitely
Yes.
mindful of that, and we want to get our cost recovery.
So hence why we should be tracking it more diligently to make sure people are repaying. That's all I'm asking.
Yeah, we have all that information, so we're aware of who owes and the amounts that they owe, and their timeframes for repaying that.
Okay, thank you.
It's not a large number at this time. Most of them are current probationers. Lastly, the consultant expert program update. We had the annual consultant training on June 23rd of this year. There were 4 new consultants appointed at board meetings this past year. 3 of them attended the training, and therefore, according to board policy, 3 of them can begin working on cases. The 4th individual, we can see if he is still interested and wants to reapply, because the training won't be held again until next June. Also, I have checked with medical board on their expert training. I recently got information that they have trainings offered the end of this month and in November. There was a delay in being able to offer that to our consultants and experts because they didn't know how many of their own individuals would be signing up. So they recently opened that up, and I've informed our consultants and experts that they can attend. About 3 so far have signed up for that training. And this is a full in-person training that medical board offers. Also, the evaluation of the consultants and experts. At this point, I am still just gathering information as cases close out in the field and with the Attorney General's office. I'm requesting these evaluation forms back, and I've enlisted the help of our program support, and next week we're going to start working more thoroughly on this, on getting information, and I'm hoping at the next enforcement committee meeting that we can kind of hash out the details on how much board involvement there is to be in the process for going over these evaluation forms. And unless there's additional questions, that now concludes my report.
By the way, the graph that you drew showing the decrease in number of complaints since we've instituted the continuing competency program is very handy, very nice graph. Thank you.
Thank you. That was developed before my time, so I only had to add to it. Thanks very much.
Thank you very much, Beth. Okay, before we move on to the legislative program, we're going to take a short break. So it's now 11:43, so we'll start back at probably 11:55. I'd like to call the meeting back to order. And before we have our legislative report, we're going to have a quick quarterly budget update with Karen Munoz, who's waited patiently.
Hi. Good afternoon, actually. No longer morning, right? Yes, I am Karen Munoz. I'm your budget analyst for the board. Been working with the board for almost a year now, assigned to this board, with the budget office for over 7 years. So knowledge of all the DCA ins and outs, I think I have. So if you have any questions after we go over these reports, I'll be happy to answer them. What we have this time is what the board was appropriated last year and what they actually expended through the end of the year. We do have a fund condition that gives you what your appropriation is for this current year as well, but we are still currently working on a projection for your full year. We're waiting for the quarterly reports that now that we're on fiscal, those have not been printed out, so we don't really have that full idea of where you're gonna be expending for. Last year, you had a reversion rate, which is always positive. We did ask for the board to have a savings within their budget as well due to revenue being brought in. We needed to keep your fund sustained. And so you expended a total with your recovery and your reimbursements of 900,000 at end of fiscal. That gave a reversion of the board almost 400,000. When you look at your fund condition, it sustains your fund going forward with the appropriation current year. It's showing a 1.4 million, but we are doing another savings just to sustain your board going forward of a 250,000, which would allow your board to remain solvent through budget year.
So just for clarification, are you referring to attachment B?
I don't have the attachment numbers in front of me.
Because we're trying to follow along and I think we're kind
I
of
apologize,
lost.
I don't have that attachment numbers. Okay, sorry. So I guess what I'm doing is I'm flipping it between A and B's, but the fund condition is your attachment B, so that is where I'm saying where it's going forward to
Into the
budget year.
17-18 projections.
So 17-18 appropriation would be listed under your current year.
Okay.
And then budget year, which is what we actually look at and we work at in the budget office, the current year and your budget year.
Okay, so when you're saying that there's a $400,000, what did you call it, remuneration?
Reversion.
Or reversion, is that the unencumbered balance that you're referring to at the bottom of attachment A?
Yes, so that's what the board was able to save,
To save.
didn't say within their appropriation, correct?
And then how is that then factored into the next year's budget?
It's not factored into the budget per se, so it's not like money that you can, as a savings, you can now expend next fiscal year. But it is a savings in your fund, so
Extends the fund
the life
condition.
of the board, as you had stated earlier. So instead of spending 1.2 or 1.3 million, you expended 9, but that also puts you more in line with your revenue being brought in.
Right. So then I have a couple questions on the variances. And is it possible for the next time we do this just to get some sort of explanation as to what the variances are? Because some of them are pretty large. So like, for example, for looks like statutory exempt EO, was that the payout for the previous executive officer? That's a negative variance. So it looks like we paid out more than what was budgeted.
Yeah, that's correct. So I believe last year was the time when the majority of the boards across all the boards and bureaus, they did get a increase in salary. So that would be that difference.
Okay, so
And
then
we do a this last year we did not do a salary adjustment. Most years we do what we call just a schedule set. We have a schedule that go through, and we do a salary adjustment to make the salaries more in line to what we are projecting, and then we just adjust the dollars below. So it would be a net zero change to your budget, but it would keep your salaries more in line of what we are projecting. This last year, due to all the other changes that we're going through in the budget through fiscal, it's just something that we didn't do.
okay.
But I believe we're going to making those adjustments. So you will see probably hopefully a less negative, especially in the EOs and so forth. But it's not uncommon to see the red under salaries due to merit salary rates that are not captured when we do it.
In the initial budget. Okay, so then, for example, the minor equipment, it looks like there was a $10,000 cost. Do we know what that's for?
Yeah, so just I want to make a statement on that, on this part. All the unencumbered, so if you're going to see some negatives on these line items, um, although on paper it kind of looks like, oh, we're overexpending in this line item, we're overexpending on this line item. The bottom line number is ultimately what we are most focused on. However, we do our best to adjust the budgets to the line item, to the object, because the line items that they're actually hitting. However, it's not always captured, and that's why we have those negatives on those line items. But with the minor equipment, sometimes those are not budgeted for in that fiscal year, because we do a line item adjustment for minor and major equipment every year. And so for minor equipment, it's doesn't mean that they cannot expend, the board cannot expend in that line item. It just means that they weren't budgeted that year for minor equipment. But the board found savings elsewhere within their budget to make those purchases.
So for the budgeting process, how much is the board involved in what goes into which line item?
We meet annually, at least once a year, to go over the entire budget and where everything has been distributed throughout. And if there are any suggested changes that they'd like to make, we will do our best to make them. Due to the new system of fiscal and the process of adjusting dollars within specific line items is just a little bit more tedious. Doesn't mean it can't be done, and I do know that we are working towards truing up a lot of the budget line items for the boards and bureaus out there. It's just, and I know that we are going to be doing that in the next year or two. But there are several steps to have to do that, and so we just make the boards feel more comfortable by just letting them know it is not uncommon to see the red on one line item. You're going to see you're going to have a higher savings in another line item.
So is there an opportunity to do mid-year adjustments, or is it just whatever's budgeted, that's what you have, and there's no adjustments like mid-year? Because I know, in my line of work, we do mid-year adjustments. We're a governmental entity. So does the state not do mid-year adjustments?
Any adjustments there is no like specific mid-year adjustments. We are going to be doing an adjustment coming up when we do the salary adjustments, and at that time that's where we would make any adjustments that we might see fit. It would have to be a net zero adjustment, so savings in this line item to be placed in that one. But but no, we don't usually have a mid-year adjustment to line items within the budget. Not that I have seen or done.
So I'm just trying to get a sense of how much control does the board have over its individual budget? Is it very minimal, or is it pretty much handled at the governor's level?
The bottom line budget, or where the money
Just
is
where
spread?
the money is spread.
Where the money is spread, if we can sit down and go over where you want to see those dollars, that's something that I can do.
Because I don't know if we've ever done that. So I'm just trying to get a sense of how much.
So Christina, let's say the $10,000 in the minor equipment, we bought a new very much needed copier. And what I did with that is, because we had vacancies, we did salary savings. So that's going to kind of what Karen's talking about. That money is going to be merged from the cost savings of the positions. It's going to offset the cost of the copier. Now, in my old line of work, what I'm going to implement this coming up January 1 is we're going to sit down and we're going to make a projection of what equipment we might need, stuff like that. And I'll bring that into the March meeting.
Okay.
And then you'll know that when we're purchasing computers or anything of significant value, the board will get a buy-off on that. Then you'll know where the savings might come from or where it's going to be hit from.
And that's kind of what I'm getting to, is just making sure that the board is informed on, the spend down and how we're spending. And I mean, because I guess the key when there's vacancies, we want to ensure that the vacancies aren't impacting work. And, cost savings, I mean, I get cost savings, those are great. But if it's cost savings that are impacting the ability to do work, then we just want to make sure that we're being proactive. And
it's just all due process in the hiring process that just takes a long time to get through HR. So that's where I grab those savings.
Okay. So then my next question is, you mentioned that you're in the process of putting together the 17-18 budget. Is there a projected time frame for when there will be a draft that may be available for review?
Well, the board has an appropriation that is already public, and that's, I believe, they have an appropriation of 1.472.
Mm-hmm.
We are going to do a cost saving, or yeah, savings of 250,000 just to keep them in the black for the following year. But the projection doc, the attachment A, that will be completed probably in the next month,
Okay.
where we can see, but the reports need to be pulled. We're still trying to make the payments. Our accounting is working diligently to get that into the system and printing those reports for us.
And then for the revenue, the projected revenue, I know that in the legislation, the fee increase is a part of that. So when will the projection of the revenue come into alignment with the fee increase? Do you know what I'm asking?
So once we get the,
Yeah.
statute for the fee increases, we're gonna have to come to the board and make a regulatory package and set those fees. Once we set those fees, we're gonna have to go through the process of OAL to get that solidified. So it's gonna be a little process, but we're just waiting for the statute legislatively to hit, and then we'll back it with a regulatory package, and the board will set those fees.
So that will potentially impact the 18-19.
Right.
Right. So I'm just for public information, because our revenue looks like it's dropping off after 18-19. So the projected fee increase will impact that
Right.
futuristically.
Right.
Yeah.
Yeah, I would say that the revenue going forward and projection wise, it would be about the same. Right now, we're projecting 987 in current year, 987 in budget year, and it's just assumed that you guys would receive the same revenue going forward, and then increase by what the fees would be at that, wherever they're set.
So then is that a typo? So the prior year adjustment is what's making the difference in the bottom line totals?
So your revenue is a total revenues line item, that would be 987. The next line item would be your total resources, which is your revenue plus what your beginning balance was from the following. What you're ending last year, and which becomes your beginning balance. So your beginning balance is 646 in budget year projected, plus the 987 is why it looks lower, the resources, but your revenues are still stagnant. They're still the same number.
And it's because you're deducting the expenditure savings.
No, that's the revenue in the beginning. Yeah, that is correct. But when we do an actuals, because everything past from current year and beyond is projected,
Right.
when we do an actuals, that will actually give us, that'll drop it from 1472 plus the 250 under current year line. Right now we're showing 1316. That'll probably be somewhere around the 1 million. If we're just being honest, around 1 or 1.1, and that's being generous, possibly, just on historical. If you look at historically, that will increase your months in reserves, and so
The goal is to increase the month in
it
reserves.
does give you time for those fees and putting those fees into regulation, and so you have, even though it shows that you have 0.3, I'm sure that number will increase and you'll have more months in reserve going forward for the next couple of years.
So just so people are clear, when you're making adjustments, the adjustments is to the fund balance to increase the months in reserve in the long run.
Yeah, so right now, that 250 adjustment, that savings that I'm suggesting, made your governor's budget, your budget year line item be 0.3.
Right.
If you save additional,
And
that's
it
just
goes-
going to increase your revenue or your months in reserve, which is what we want
Right.
at this time.
Right.
Until you do get that fee
The
set.
increase, which will then make it even better.
Well, then you can expend a little bit more and
Or we'll
if
expend
needed.
what we're consistently expending and have a longer
Yeah.
reserve. Yeah.
So, and when you do, when like, well, going back to your projections and your line items and so forth, you have your, like your major and minor equipment, that's actually coming down the line soon. And so we can increase your budgeter for those if you need additional equipment. And so that's a request that the, Kathy will send me saying that they need this equipment and it might increase your budget by that, so you could purchase it, so your line item could, if you want to see that in dollar in your budget, that's how you get a budget in that line item. It's a request by the board.
Okay.
I don't have anything else to add. If you have any more questions.
The numbers are the numbers.
Yeah,
Well, thank you very much for your report.
no problem. Thank you.
And thank you, Karen, for all the help that you're giving us and spending some time with us today.
Ms. Cooper, you're on.
Good afternoon. My name's Kathy Cooper, and I'm here to present the legislative and public education reports to the board. So I'll start with item 9C on the agenda as to the 4 bills that are affecting, well, actually 3 are affecting us. One is here as a courtesy. It's a HR bill that Dr. Mansdorf is very involved in. We've seen his picture there when they were showing the efforts made by the DPM community, and I'll get to that in the last part of my analysis. But let's start with SB 798. I know you've had a chance to look at all my attachments, and I think we're up to date with what has happened since June when we talked about these 3 bills. But today is the last day for amendments, and that's why I'm sure Vincent couldn't show. He was supposed to come, but they're very, very busy over there. And SB 798 is the one that we're not as sure of. It's not because of anything that has to do with the Podiatric Medical Board, but more with the osteo and the medical board itself. So at one point this summer, this bill was put on a hiatus. It was stopped, and it's come back. But whether it's as secure as 1153 or 547, I don't know. So I'd like to explain to you, you have a new handout because on September 6th, 1153 was amended. The language that was added at the very end is procedurally needed if 798 should not go through. Very difficult to read, not common sense, but the experts at the Capitol know what they're doing, and what they're saying there is whether or not 798 goes through, 1153 will go through. And it's because your scope statute 2472 has to deal with what you can and can't do. And the California Podiatric Medical Association has been very successful with 1153, which allows doctors of podiatric medicine to treat ulcers or other skin conditions below the knee. If 798 does not go through, 1153 affects 2472, Section 2472 of the Business and Professions Code, and you will be protected from anything that might or might not happen. In other words, you have 2 bills right now that are dealing with the exact same section. So they're just assuring us in 1153 that this is an independent bill. You will get that new Section F, which allows you to expand your scope to a certain extent. And we're very secure with 1153. 798, we'll find out today what last amendments, if any, are made, but we don't expect them to affect this board. So just to kind of give you the overview again, SB 798 is the medical board's sunset bill, which has expanded into affecting the osteo board, our board, and other boards. But should 798 go through, starting in January, we will be separate, reporting directly to DCA, no longer reporting to the medical board. And you're exactly at a 60-year mark. So this is a big deal because in 1957 you were established. The committee was under the medical board, and now 60 years later, exactly 60 years later, you will become an independent medical board of your own. And I want to assure you, Brian has maybe something to say about this or not, but we were just so happy to understand that all the players, all the stakeholders, including the legislature, as well as the heads of the medical board, et cetera, will recognize this board as the third medical board here in California. So I knew there was some talk a little earlier about whether we would come in the disciplinary requirements to perhaps report that there was a complaint made. And I'll point you to page 29 of 798, which I know Joe has created a much easier way for us to refer to the same pages. So if you look at the bottom of the middle, somewhere around the 800s, 803, we are now being added. So it won't be exactly the same as the medical board's requirement, but what I can tell you is for the next 3 to 5 years, my guess is we are all going to be bringing cleanup language. And whether or not we're included with that disciplinary requirement or not, for every privilege, there is also a requirement. And my guess is as MDs, DPMs, or DOs, we will all be held to the same standard eventually. It'll all come full circle. We won't be treated too much differently. So what we're going to ask the board to do if 798 goes through is to help us, because from what I understand, all of the reporting as to new language, in other words, we've been referred to as the medical board from 1957 till today, and we're not always included in things because by virtue of our jurisdiction within the medical board, they never mention podiatric board. So we can't find these that easy. But over the next 6 months or 3 to 5 years, however long it takes, we're going to be trying to clean up our statutes, clean up our forms. And we all know that there'll be things that don't come up until they come up, until they, something points us toward that one issue. So if any of you notice that things don't gel starting in January 1st, like I'm confused. I used to go to the medical board to find out about cures or something. Well, we won't be within the medical board anymore. So we have to have that on our website too. Things like that are going to be coming up. Everybody's anticipating it, but no one's going to do that work for us. So as far as 798, should everything go through, we then will be the independent medical board. And we are also taking out the ankle cert language, saying that if you graduated after 1983, you blah, 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 that will be gone. And we will be independent. As far as 547, this is the exact same language that was brought before this board in November of 2015. And we tried to get the fees raised last year. They brought it to the medical board sunset report and were included. Then they took it out and put it in 547. It's called a weights and measure bill. And on July 11th, we testified in favor of it. As you will see, 798, 1153, and 547 all have letters of support, which this board authorized Brian to sign. And they were sent to the appropriate people at the legislature showing our support of these bills. So it looks like all three of them will go through. Now, 1058, I just want to mention this is a huge win for podiatry, for the medical doctors that practice, in that there will be parity, should that bill pass, at the Veterans Institution, at the administration, and in terms of pay, and I don't know exactly how the reimbursement of your practice laws will be affected, but what it is going to give parity so that you're paid equally for doing the same work. And I have the reviews and I have the press releases included in this report. So before I get on to the regulatory section of my report, are there any questions about these legislative bills?
I have a question, and it's not necessarily related to the bills themselves, but it's just the process of implementation. You mentioned that there's a process to happen where there's going to be some cleanup. Have staff spend some time thinking about what that implementation process will look like, and will that be brought to the board for review, or will it be handled in committee? Just what is that looking like?
Brian has had us meet on this topic, and until it is right before us, we probably will not have a written plan. But what we are all aware of is that there are references to medical board when they meant podiatric, because we've been under their jurisdiction. So say there was a list of 25 boards. We weren't listed in some of these areas. the medical board is listed, and by virtue of our jurisdiction within the medical board, we're included. Now we have to find all those, and we have been looking, and there are people much more adept at this at the legislature, also at the medical board, that have been doing it for us. They did a really good job on 798 of trying to find every area. For instance, licensing, that's all included in 798 too. So where the medical board was issuing our licenses, we will be issuing the licenses, et cetera. We could use help from all of our stakeholders, and I'm sure we're going to be hearing directly from you, from licensees that are saying, wait a minute, this needs to be changed. It's no longer looking the way it used to look. So no, we don't have, this is kind of like finding a needle in a haystack. I'll give you an example. Someone had a question about acupuncture, and that's when I, along with the previous exec, thought, oh my gosh, we need to make some changes. It wasn't within our radar until someone brought it up. And it's that type of thing that we're anticipating. So we can read those statutes till we're blue in the face. We probably won't find the conflicts. It's only when you're trying to fill out a form or you're trying to register for something online, and then you realize, oh, this might need to be addressed.
So I think the statute part is just one aspect of it. What I'm more interested in is, and I know this is kind of getting ahead of the process, but it looks very likely that these bills will pass, right? I mean, that's the way it's kind of leaning at this point.
1153 and 547, yes.
Right. So from a public perception standpoint, just from an implementation standpoint, I'm just wanting to hear that we're thinking about that, and that we're looking for ways to engage our licensees, to inform them of what the changes are and what the changes will mean. And is that something that's going to be talked about at the December meeting?
Yes. Yes, to all the above. I do have a skeleton implementation plan because of the controversies with 798. I was just waiting to hear. It has the heartbeat again, and it's probably going to go through. Yes, it's going to go to committee. It's going to come to this board. It's going to take all of our efforts to comb through all this stuff and make sure that our licensees, our stakeholders, and above all, that we're providing the best protection to make sure that we get it right. Knowing that, saying that, it's just going to be a work in progress, because there's going to be that one instance that we don't deal with all the time that's
Right.
going to come up, and we're just going to say, shoot, we forgot about that, or we didn't know about that. So we're just going to have to make that list. So it's going to take all of our efforts to make this transformation happen.
Okay.
What if there's one of these things that comes up and it's actually tying, decreasing or denying or not allowing?
Well, we have a section in there, and I just can't remember it off the top of my head because I've been reading sections since I started this job. It's going to be as practice was. So
Okay.
nothing is really going to change.
Because it could, takes a,
It could take a legislative cycle.
It's
right?
absurd, yeah.
Yeah,
I mean,
but we do have that one section in there is business is going to be the way business is done. So we do have that insurance of that code section. I just can't remember off the top of my head which one it is in there. And that was crucial for this to happen correctly.
So we've been calling that a catch-all phrase. And what it means is if something were forgotten and we couldn't enforce the law or something, it's a catch-all saying, if this change affects anything like that, it shall be as it was.
So then the next question was, during Ms. Huckle's presentation, there was a mention of potential name changes. So will that then be a part of that presentation that goes to the committee?
Yes, that will start at the committee level. There will be a robust discussion about that. There has been the terminology of the Podiatric Medical Board of California. But we need to weigh in from the board, and we need to get action from the board and a vote from the board for me to go forward.
And is that, I mean, I would think from a public perspective, that would be a great way to engage the public.
That would be 100% consumer protection. It would identify this board as a medical board, also for the stakeholders, the profession, and above all, the constituents of California, 40 million.
Okay. So we looked for ways to get buy-in from the licensees and the
The
public?
associations, and so we need to have that robust discussion once we get it agendized.
Okay.
So let me point you to page 67. I'll just read the catch-all language. The amendments made by the act adding this subdivision relating to podiatrists shall not be construed to change any rights or privileges held by podiatrists prior to the enactment. So that is to protect you in case someone were to say, well, you're not getting a license from the medical board anymore. You can't lead this surgical team here at this clinic or something. I mean, I'm just giving you an example. This will be what we look to say, no, no, no. This was never intended to change the rights or privileges of a DPM. It's a big thing, and we probably will be using it at some time in the future.
We had a discussion about changing all those podiatrists to doctors of podiatric medicine. Is that elected not to do that?
No, I think it was an oversight in that we have made that effort, and most times they are including it, but, you know, we can't, this bill was so controversial that when we brought that up, they said, you know, we're not making that change right now. We did notice it, but it wasn't on their radar as an important thing. However, next year, maybe we could do a global change.
Right, that would be some cleanup that we can do in a sweep on next legislative cycle.
So really, with the addition of that catch-all phrase, 798 is not of a serious concern to us in terms of privileges of our licensee base.
I just feel like, you know, like all these bills, it just is like this mad rush at the end and, oh, have to do it. And this is just too bad. This is the way you're taking it. And, you know, I mean, that's, you know, my opinion, not the way these things should go, but that's government at its finest, I guess. I don't know.
This has been a long time coming, this separation, as we know.
Mm-hmm.
But having this catch-all phrase
Mm-hmm.
was very much a courtesy given to us by the Senate leaders, or maybe even the Assembly, I'm not sure. But they don't want to change your position. They understand what we were saying last year, and I think they respect it. It's just that we really are no longer under the medical board. I mean, they don't review anything that you do, and I can understand why the Senate wants it separate. So couldn't stop that train. Okay, so that's 798. Any other questions? 1153 is straightforward, and 547. And just to let you know, on those fee increases of 547, this will be brought to you before it goes to the regulatory process, which we've learned from oral arguments can take 2 years or almost. So as far as those fees, those unscheduled fees showing up, it probably, we've done the projections with the IT department because so much of that has to do with the website and things like that. Probably 2019 would be the first that we'd see any more money coming in. And we don't know really if it will be the projection on the low end of 11,000 or on the high end of 14,000, because if somebody wants a duplicate license and they're paying $1980, literally mid-$1980, that was the last time you had a fee increase for these unscheduled fees like duplicate license, et cetera. They may not want to pay $100, so they might not order it as often. We don't know. But we're expecting it might generate a little bit of revenue, 11 to 15, somewhere in there. But not till 2019. So with that, I could go on to the regulatory report. And what I would like to say there is the oral argument section has now been put into law. We're expecting the printed version from the Secretary of State any day. And what that allows you to do is when you hear the cases on appeal from the ALJ, you didn't have any rules, procedural rules. So the plaintiff or the person who is appealing, the appellant, would come before you and say, well, I want to talk for a half hour. And the other person can say to you, I want to talk for an hour. Those are not the normal ways of appeal. So the legislature mandated that we adopt rules, and we did. You approved those. And so the next time you hear a case in closed session from an appellant, if that person doesn't want to accept the findings of the ALJ, you will at least have procedural rules, just procedural rules as to timing and things like that. So that's what the oral argument will give you next time you have an appeal. Now remaining is the regulatory substance abusing guidelines, what we've been referring to as SB 1441. And Brian is leading both Bethany, myself, and legal counsel onto a schedule that we are going to be drafting something for you to look at again. You looked at it earlier under like 19, I think it was 2015, but it's different now. So there have been multiple attempts at other boards to comply with SB 1441, requiring substance abusing licensees to follow a certain procedure. We now have the tools because of the proven medical board's substance abusing guidelines that we'll be using as our model. And we'll be adopting it as best we can, bringing it to you. Once you approve it, we'll process it through the OAL. So that will be coming up in I believe, the next board meeting as well. So this sheet that we see as a matrix, we call it, it should be pretty empty next time you see it. You see one thing on there. It'll be substance abusing guidelines. I hope. Are there any other questions about the legislative part of my report? All right, so I'll go
I
on.
have a question. We talked about, we've been talking about Hill visits as a part of board meetings. So is that something that we're gonna see a plan for?
I reached out and I was told that pretty busy at the point. So next legislative cycle, I will try to set something up in advance where we can do that. That's in conjunction with the Sacramento board meeting. Unfortunately, we meet on Fridays, and sometimes the assembly and senators are maybe out, but we can always talk to the chief staffers.
Probably it would be the June meeting because the March meeting is in Southern California or, outside of Sacramento. And, December, they're not in session. You can meet with staff, I guess. If you directed, Brian could help me schedule whatever it is, but it'd probably come more, if it's coming on a board meeting day, impossible for March, it'd be June.
I thought when we set the meeting schedule, we left it flexible, that it wasn't necessarily on a day, but it was frequency. And then aren't we setting the calendar in December?
In December, yes,
So then if the goal is to do a Hill visit or some sort of legislative day,
Mhm.
then couldn't we factor that in to the schedule for next year? And if it needs to be on a day other than a Friday, build that in?
Absolutely.
I just think as a matter of board participation and just engagement with the legislature, and that's a very important aspect. And I don't want it to just be the legislative committee doing it. I think it's something that's beneficial for the board, just as far as our advocacy goes, for us to, do that, especially with all that's going on and the changes that we know are coming. We do, I know that there's several of us that would be very interested in just being able to do that and be able to advocate on behalf of the board.
Thank you. We can do it. We were setting up 15-minute meetings. I think one day we had 8 meetings or something. But we can do that for next year at your direction.
Oh, absolutely. And just to add to that, I know a lot of groups do, action days where maybe the medical profession or maybe the podiatric, and we can get some medical professions to come with us. So, especially for me, I don't have the medical background, but again, trying to advocate.
Well, the California Podiatric Medical Association, I don't have the date, but has already scheduled a date next year to visit Sacramento. We could meet then.
Right. That would be the best date, I think.
Sounds good.
Get the most out of it.
So we could talk about that in December and maybe get that date on the calendar to participate with the CPMA when they have their day at the legislature.
All right, moving on to section 2 of my report, the public education or outreach. We've had a lot of great feedback on the newsletter.
I do want to say, if you haven't read it, you should go
Let's
on.
publish it again.
It's a really good newsletter.
We
I thought
could,
this
Doctor.
month I think this one was the best one.
Well, it's our second one, so we're pretty new, but it's the right
That's
direction.
pretty good odds. I like
Yeah.
that.
No, I like that you included the student perspective. You included the expert witness section. I mean, that was very inclusive of the whole thing.
Well, we've been contacted by the school, and they're willing to give us a regular section. And of course, we have to be equal with our other school and offer them this when we develop a better relationship when we go to that location as a board, I think. But I think we've heard from DCA people and other people that read it. They were happy with it. Now that we have our renewals online, we're going to put that into a prominent section and try to tell everybody, you can register online. Although they didn't really need that guidance. People seem to figure it out. They expected it, and we've been getting a lot of participation with that. As far as any other articles or topics, please feel free. If you're just going through your daily life, you could send it to me at any time during the year, and then I'll just keep it, on target for a new topic in the newsletter. It doesn't have to be by the deadlines, which, by the way, is the end of September. So if you have something you'd like discussed in the next newsletter, we really need it sooner, but at the latest, the end of September.
So I have a question about that. This legislation about the wounds on lower extremity, when will that be passed or not
Well,
passed?
today, if it's not amended, which it isn't expected to be, the governor will get it. There's no controversy. We're expecting it'll be signed at the beginning of October, if not before. I think he has till October 15th. And then January 1st, it becomes law.
Because that would be probably a good article just about diabetics, their lower extremity and dysvascular limbs, and the role podiatry plays in that whole management with this bill being passed.
Right. Maybe I can interview you and
Maybe you can.
put it in a question and answer for the newsletter.
One of our preeminent wound care podiatrists is relocated to USC. David Armstrong might be happy to write this article.
That's a great
He's
suggestion.
now one of ours.
Yeah, I've seen his name, and Dr. Cha had some professional articles I read. He was mentioned many times, so I will ask you for his contact information if I don't. Oh, I have it. I'm sure in the licensee data. So, okay. So, any other things about the newsletter? Please just send me an email or let me know you're interested in a topic.
I'd like to have an explanation of the rules for prescribing medications from other countries.
I know what you're talking about, the Canadian suggestion that we use something that we didn't have FDA approval.
For those things they do have, is there any rules for writing for Caflex or anything and getting it at such a discount from another country? Do we have to do anything? And then what about a medication that is not available in the United States but is available in other countries?
I'm no expert, but I think I've heard many people leave this country to go to other countries for that purpose, but
I mean, are
We'll
there
find
any
out the
rules
law.
on writing for that medication?
right. It might take, it might take a second edition because it's kind of
Just
involved,
throwing a
but
topic out.
we could work with our attorneys maybe.
I have one from a patient perspective, because I also want to make sure that we're also including patient perspectives. I know that there's oftentimes challenges related to amputation after diabetes or, as a part of that process. So I think it would be an interesting article to see something on life after amputation, just to kind of show people that you can recover from that experience. And then I also want to see a standing section in the newsletter around complaints, if it's not already there, just so we are continuously letting people know how they can file complaints. And then how is the newsletter currently being distributed? Do we have standing ones at DCA? Are we shipping them out to our licensees? Like, how are we distributing the newsletter?
We have a listserv, and we have appointed toward those people on the listserv, here's our newsletter, but it's not as expansive as we'd like it. And we're working on a survey that will give us the right to, use people's emails to send them the newsletter. Right now, we pointed toward the website. It's been published on the website, and it's prominent on the first page up top. So the newsletter will come out. If you come to our website, you'll have that option. We also have distributed it among other DCA entities, and we didn't do a mass mailing. We don't have a budget for that, but we could if you wanted.
I just think from a public perspective, I think that's getting only a small portion. If I'm thinking about people who could benefit the most from this information, would they have access to a website? Would they have access to email? So I just want us to be a little bit more broader in our scope. Senior center seems like a great place to have this newsletter. Hospital lobbies, especially when there's places like the one at Martin Luther King in South LA, where diabetes care is really big. So I'm specifically thinking about communities, urban areas, rural areas, communities of color, where they are being the most highly impacted by things that are related to podiatry. I would like to see that the newsletter is getting out to those folks, and I don't think an email or a website is going to get it.
Okay.
I mean, maybe it's, reaching out and having them print copies. I mean, I think there's ways to do it. I agree with you. But I mean, we're here for the public, so we can't, if there's something that, this is a low cost venture, I think the key is to get information out.
I think it's a great idea, and we will make it happen.
Okay, also, could we add maybe on the newsletter, I understand this is being live streamed, our board meetings, but we don't get a lot of public comment, and maybe that we need to kind of put that out there so people are tuning in, and maybe we'll get some more feedback. People will look at the agenda, or some type of information of how you get a hold of the board, or how you look at the board agenda, or where you find the live stream. So at least the community and the public know what we're doing, and they have access to it.
And I think to that point, the other thing that I'm thinking of is language access. And I know that's more expensive, but even if it's available in other languages on the website, I just want us to be mindful of the population.
Thank you for those suggestions. They're very helpful. And I want to say too, in terms of cures and outreach, we have reached out in many ways. And the last one was at the CPMA meeting in June. They included a letter to our licensees, to DPMs from actually outside of California too, because it was a regional meeting, and asked them to participate in cures too for these various reasons. So I believe all the podiatrists in the West Coast, including Arizona and New Mexico, were at that meeting and got a copy of that within the newsletter, their newsletter, CPMA's newsletter. So we felt that was a successful outreach. All right, so this concludes my report. The next report will be made before the board on December 1st, 2017. It's a Friday.
So before we move off this topic, there's actually a third agenda item that I would like to see continuously reported out on, and that's the website, because that is our main public interface. And to that point, so for example, I had someone ask me, how do they see live stream the meeting? And we went to the website and there's no link to the live stream. So can we make sure that that is available for people to view? Because right now you have to go to a separate website. And so for public access, we need to make sure it's more accessible. And then I know that there's been some revamping to the website. So can we just kind of continuously get updates on what's happening, and then be able to maybe provide feedback? Because I know a lot has changed. So I think having that as, a standing item where we're getting updates on it would be beneficial as a part of the public education feedback.
Thank you.
Include what pages are visited most and
Sure.
where they kind of, I think they give you a timing of how long they're on each page.
Yes.
That would be really beneficial. Thank you.
Okay, we can get that. Any other comments or thoughts? Thank you. That concludes my report.
Thank you very much. To the executive management report, Mr. Naslin.
Okay, this is going to be pretty quick. I just want to get you guys up to speed. A couple of months ago, it was brought to my attention that this building that we're in now was sold to a new owner, and the leases is going to be up here in a couple of months. So all the boards have met, all the executive officers have met, and there's some boards that will be leaving this building. My decision was to stay here because the medical boards are going to stay here because we have the shared services. So there's going to be a couple more meetings in the future. We had one just the other day, but I was in another meeting with agency, and we're queuing these meetings up. Just to let you know, they're looking at some tenant improvements in this building to make it more palatable for the employees here. The atrium, maybe a concession stand with a coffee vendor, and sprucing everything up with new paint and stuff like that. With that being said, I have included the lease here, and when I go forward, I'll probably be able to give you a better report in December as we go in and sign this lease with DGS and DCA. It looks currently, right now, we pay $152,000 in rent. Our actual price per rent is $1.71 a square foot. With the tenant improvements that they're proposing, we don't have what that rent is going to cost. We're anticipating, anywhere somewhere between a few cents higher than the 171 to maybe up to the $2 range. So I just wanted to let you, the board members, know that there might be a hit to our budget. We do have the option to back out of the lease and find a new facility. But remember, if we do that, we're going to be paying some extreme moving costs, relocations, and build out. So as information comes in, probably when we have our committee meetings in November, it would be, I'll have new information, and I want to run it by you and get your approval to go ahead and initiate a new lease, as long as it's within the parameters of our budget.
So a question on that, is the current space that we have sufficient for our need, or?
For our board, it is way sufficient. We have plenty of space. We still have accommodations for 3 more PYs, or individuals, if we ever got lucky and got positions. The file space for our secured files, ample. So I think we're fine as far as space. And the conveniency of the location for the employees that travel from home to work is in a good location. And plus we have the public utilities, or not the public transportation, the light rails available right out here.
So as far as, you had said other offices are deciding to move out, are any of those offices a little bit updated? Is that,
They're all about the same.
okay,
They all need improvements. There's some floor issues in some of the other suites. There's paint issues. The other boards need to expand. They're just growing rapidly, so they're just getting cramped. So that's what DCA and DGS are working on, different options to keep those people here and expanding. So those are the robust discussions that we're having with all the EOs in the building. So as far as I think right now, I think we should be tethered with the medical boards because of our shared services. It's important to have that interface and that immediate interaction with them on the different businesses throughout the day that we do with them.
I just thought maybe there was a better office location that was a little bit closer, or maybe a little bit bigger, or the configuration of somebody leaving might be,
Right, I don't,
put our stake on it now.
there might be one that's a little bit bigger, but I don't think we can afford it in our budget.
Thank you.
Okay, well, do we need a motion to allow you to negotiate?
There's actually no language in the agenda that contemplates board action on the lease at this time.
Yeah, so I just wanted, if this is a discussion update, and by December or November, the committee meeting, in the executive committee meeting, if we get there, I could get the action there.
And we're meeting here again in December,
Yes.
and we need to plan a couple of meetings next year in Southern California or elsewhere.
Right. So that concludes my report, or my discussion.
All right.
Thank you.
So,
10, future meeting dates and items for future agendas.
okay. This is what I have so far. A discussion and possible action. This is the December meeting, December 1, is it?
Yes.
Sacramento. Discussion, possible action, board name change. AG's office case training. Gloria. We need to elect new officers, new positions, and new committee assignments for the upcoming year. We need to figure out board meeting locations and dates. We need to have a discussion about the frequency of our meetings, meaning 3 meetings a year or 4 meetings a year. We need to, I believe Gloria's going to get back to us, and Gloria left, about the cures presentation through her office.
So Brian, just clarification,
Mhm.
I think we need to revisit the bylaws because it spells out how many meetings we
Okay, so
have.
in the bylaws?
Yeah,
Okay,
so if that changes, we would need to,
gotcha.
either it's in the bylaws or the administrative agreement. I can't remember which one, but we spell out the frequency of meetings.
I think legislatively it says that it's up to 3 meetings, or the board can meet time to time, but legislatively it's 3 meetings. Must have 3 and 1 in Southern California.
Right, but in our board approved administrative agreement,
Is it there?
I think it,
That's totally up to you to change it anytime.
right, but what I'm saying is we've already agreed on that. So if it's, anything's gonna change, then we would need to change that document.
Okay.
Yeah.
I got it. Update to include the website. Anything else I'm missing here?
I think as part of the AG report, I think what we're looking for was to have more of a training on that, but not just looking at the case reviews, but an overview of the entire process. Because, and I forget her name.
Gloria.
Gloria, she mentioned that there's 4 components. So as a part of that, we would just kind of want to see that, she said she had a visual. So I just want to make sure that that's a part of it. The case review is definitely what we're interested in, but we're also interested in kind of understanding more about the vertical enforcement and how that process flows and how the board members are involved in that process.
Okay. And then also in closed session, I think we'll have some closed session on some disciplinary cases and also the evaluation of the executive officer.
Yeah.
No comment.
And will there be the budget discussion? Because I think. and
Yeah, we'll
budget.
have a budget. We'll have the regular reports, the executive officer reports. That's always going to be consistent, but these are new items. Is there any other things you would like to discuss in the December meeting that would queue up for the following year?
I think you need to be on the mic.
Would there need to be a motion to accept, approve your executive
Yes.
So for the public, do we need to,
So I need a motion to accept the executive report, which included the licensing, enforcement, legislative, budget, and management.
so moved.
Second? All right, we'll start the roll with Dr. Manzi,
Aye. Judith Manzi, aye.
Christina Dixon, I.
Michael Zappi.
Darlene Elliott, aye.
Now I guess it's time to accept a motion for adjournment.
I just have one more thing.
What's that?
I would like to introduce our new attorney officially, Tara Walsh. She's going to be our new counsel to the board. And I personally want to thank Gary Duke for all of his service he's done to the Board of Podiatric Medicine. And that's all I got.
Now I'll accept the motion.
Can I say one last thing? I also want to thank staff for reorganizing our agenda, and the packet is beautiful and easy to read. So I appreciate all the time and effort you guys all put in for us. Thank you.
That was Joe.
Yes. Please let him know. Thank you.
Maybe the double pages on an angle, on the side, though, would be all the same way, so you turn. Hard to do that on airplane.
Yeah.
We're still waiting for that motion to adjourn.
So moved.
Second.
Second? Okay. Let's start over here.
Darlene Elliott, aye.
Michael Zapp, aye.
Christina Dixon, I.
Judy Manzi, aye.
I thank everybody for their time and attention.
Thank you.